Very interesting decision there today reported in the newspaper, in the media, from the Court of Appeal about the Bewleys Cafe in Grafton Street. The fascinating thing about this was there was a dispute about the windows in that building. So the Bewleys restaurant in Grafton Street is obviously occupied by Bewleys, but Bewleys are only tenants and they have the lease. So the developer, Johnny Ronan, his company actually owns the building and he's the landlord. There are 6 windows there in that restaurant. They're Harry glass, stained glass windows, and they're said to have a value of about €1 million. So there was a High Court dispute about who owned the windows. The High Court determined, after looking at all the evidence and looking at the lease and so on and so forth, that 4 of the 6 windows belonged to the landlord, and 2 of them were actually fixtures of the tenant. In other words, 2 of them belonged to Bewleys, 2 of them belonged to the tenant of the building. So Johnny Ronan or his company weren't happy with this, obviously, and they appealed to the Court of Appeal. And the Court of Appeal, and the other side then, the tenant wasn't happy either, and they actually appealed to the Court of Appeal. So Johnny Ronan was arguing at the Court of Appeal that the 6 windows, 6 Harry Clarke stained glass windows in Bewleys belonged to him, the landlord, the owner of the building, and the tenant then, Bewleys, they were arguing that the 6 windows, not just 2 of them, should be their property, tenants' fixtures. The Court of Appeal has determined now that the 6 windows actually belong to the landlord, to Johnny Ronan or Johnny Ronan's company. There was 3 persons on the Court of Appeal. 2 of them said that Johnny Ronan's company owned all 6 windows, but there was a dissenting judgment from, can't remember now, it's the judge actually that, I think it was the judge that Enoch Burke's family had a problem with on the Court of Appeal, but hers was a dissenting judgment, and I think she took the view, and her judgment was that all 6 windows should have belonged to the tenant. So you have a remarkable situation here where the High Court has determined that 4 of the windows belong to the developer Johnny Ronan, the landlord, 2 of them belong to the tenant, and then the Court of Appeal decides that all 6 windows belong to the landlord, whilst one of the Court of Appeal judges determined that all 6 windows should have belonged to the tenant. In any case, if you are a lessee or if you're a landlord, generally as a lessee, with the lease, you're actually leasing a cube of space. Generally, you don't own the walls. Generally, the walls belong to the landlord, to the building itself, and obviously the walls and indeed the windows as well. So that's how this dispute arose in the first instance, when Bewleys were taking on the lease of this building. Were they just leasing a cube of space, which would be the normal situation, or were they getting the windows as well? In other words, they might have said, okay, we're not getting the walls, but we're getting the windows. And obviously, ordinarily, the windows aren't that important, but in this case, when you've stained glass windows by Harry Clarke and they're worth $1 million, then they're probably worth fighting over. But it's an interesting case, and it's an interesting ruling for anybody, any landlord or any tenant as well, because the same principle will apply to a dispute in an apartment block, in a small shop, in an office or anything else. If you were on a lease, well then generally you are occupying or taking the cube of space that's available, but generally the building itself, including the walls and the glass and the windows and so forth, belong to the landlord. Hope you find this video useful. If you do, I'd appreciate it if you hit the old thumbs up button down below. Thank you very much.